The clerk will call the roll. Yeah. Roll call. The clerk will close the roll.
A quorum is present, Mr. Chairman.
Okay, thank you, Mr. President. I appreciate everybody being here, and assume we'll be civil and listen to each other's views, whether we agree with them or not. The first bill is Senator, yes, Senator Norman.
Mr. Chairman, thank you. Before we take up bills, may I make a motion, please, sir?
Go ahead.
Mr. Chairman, at the last committee meeting, we certified a number of incumbent judges that had been interviewed, and one judge was removed from the list of certification, and I'd like to respectfully move that we certify that Judge Charette, please.
Okay. Is there any opposition? Yes,
Mr.
Senator
Chairman.
Morrissey.
Mr. Chairman, I need to speak with Senator Lucas about that, so can we pass that by temporarily?
Yeah. Without objection, we'll pass it by temporarily. Okay, the first bill we have before us, Senator Reeves? Yeah.
Thank you, Mr. Chairman. If I could bring the committee's attention to Senate Bill 499.
Senate Bill 499, specialty docket, veterans docket.
Mr. Chairman, several years ago, you all probably remember me standing up here with John Newby, our Commissioner of Veterans Services for the state, petitioning this committee as well as the House committee to set up a separate Veterans Treatment Court. Through much consternation in dealing with the House, we wound up actually allowing that authority to go to the Supreme Court to set guidelines for a veterans docket. Mr. Chairman, members of the committee, the veterans docket in the Commonwealth of Virginia has done exceedingly well. We have 7 of those established now. And over the last year, I've been working with members of Congress and the U.S. Senate to work on a federal veterans treatment court. And that bill, Mr. Chairman, now has been signed by both chambers, sits in a committee of conference waiting for the president's signature, minus a couple of technical corrections to that bill. So that bill is going through. I had put this bill in on the reconvene because we knew the status of the bill at the federal level was absolutely going to be signed. I was assured by Speaker Pelosi and McConnell that it would be signed, and it sits waiting for that now. So this is basically an addendum clause to the original bill that just says that any veterans docket authorized and established as a local specialty docket in accordance with the rules of the Supreme Court shall be deemed a veterans treatment court as that term is used under federal law or any other entity for the purpose of applying for, qualifying for, or receiving federal grants. So we have an opportunity to get grant money here. We desperately need it with all the veterans that we have to continue the good work that we've done there. And that is the bill, Mr. Chairman.
Senator Reeves, do you know how much money might be available to Virginia?
Well, I know there's $500 million in the current appropriations sitting in Congress right now that has already been approved. If we can get this passed, I think we could get a pretty good share of that. I wouldn't tell you exactly how many because we're dealing with all the states, but I would think anything we have now would be better than nothing. So.
Now, does it have to be called Veterans Treatment Court Program in order to get federal funding?
It does, and this mirrors the language, the federal language of the bill that's currently in place. And so we're trying to align that as close to possible, and that language has actually stayed the same in the current bill that's been signed by both chambers.
Okay, and it requires an emergency clause.
It does, sir, because if we wait till July, we miss out, and we want to be, as soon as the bill passes, the funds will be released, so we want to make sure we're first in the queue to get the funds.
Okay. Anybody want to ask questions of the patron? Or is there anybody would like to speak for the bill or speak against the bill?
Mr. Chairman, if
Yeah.
Speaker Pelosi supports it, I move to report the bill.
Only if she supports it? Okay, it's been moved and seconded that the bill be, yeah, bill be reported on a bipartisan basis. All in favor of the bill, vote aye. All opposed, vote no. Actually, we have it. The clerk will. Ayes 15, no 0. The bill is reported. Thank you. Thank you, Senator Reeves. All right. The next bill, Senator Stewart, 154, allowable purposes for restricted licenses. Oh, do we? I'm sorry. I'll tell you what. Let's get those. I'm sorry. Senator Hanger's next. I guess I didn't see you hiding behind everybody.
Yes, good morning, Mr. Chairman,
Yes,
members of the committee.
Senator Hanger, nice to see you.
Yes, good to see you. I have Senate Bill 929 this morning, Mr. Chairman.
929, temporary location of district court for Augusta County and the city of Stanton.
Right. The County of Augusta is in the process of moving courts out of the city into the county into temporary location so that the court facilities that are in the city of Stanton can be rebuilt. This would allow the Commonwealth's attorney in city of Stanton and the county asked that I put this in to make it clear that they had authority to sit outside of the city. They thought there potentially could be a challenge to any rulings if they were not sitting where they were designated. So this would simply clarify that they can move temporarily out into the county until the new court facility is completed.
Mr. Chairman,
Senator Overton.
just don't want to run afoul of some of folks in Augusta County who have strong feelings about this. This is something that's universally supported by folks. I mean, it's not part of the, it isn't going to enable those who want to move the circuit court?
No, apparently the circuit court is a different status. They weren't concerned about that, so it was just the juvenile domestic relations court and the general district court.
With your assurance that I'm not going to get in trouble with those people,
Okay.
I'm good.
Is there a time frame, Senator?
No time. Well, obviously there's a time frame as far as the proposed construction completion, but the bill itself merely states that they will move back once it's the new facilities are there.
Senator Stewart?
Mr. Chairman, Senator Hanger, I don't have any objection to this, although I'm aware that if you move the circuit court, certainly, and maybe others, you have to have a referendum if it's not land that's contiguous to where it is.
Right, right.
And I just wonder if this language where it says you can sit until such time as another place is designated by order of the Chief Judge of the 25th Judicial Circuit. Does that language, I mean, I understand you're trying to allow them to do a temporary place, but does that language run afoul of that referendum provision? I don't know the answer to that.
I don't believe it does in that in this instance, the court is of course in the city and it will temporarily be moving out into the county for this and I think that the language you're referring to applies to the circuit court as opposed to these courts, but I'm not sure of that.
Just circuit court?
Yeah, right.
Yeah.
Okay, thank you.
Okay. Any other questions? Okay, is there a motion? Is anybody who would like to speak in favor of the bill? Anybody want to speak against the bill? Is there a motion? It's been moved and seconded to report the bill. Any further discussion? All in favor of the motion, say aye. Or rather, vote aye. All opposed, vote no. The clerk will close the roll.
Ayes 15, no 0.
The vote is reported by a vote of 15-0.
Thank you, Mr. Chairman.
Thank you, Senator Hanger. Okay, now, Monty Mason, Senator Mason.
Mr. Chairman, Senate Bill 681. I've not spoken with anyone in Congress about this, sir. This is an attempt to raise psychiatrists, clinical psychologists, and any expert appointed in the criminal case to do an evaluation's fees. We haven't raised them since 2007. They're $750. The average time is at least 8 to 10 hours for an evaluation. We have 223 evaluators signed up. 121 of those are private. And so this isn't going to help our supply. We need more people doing this type of work. But what we hope that it'll do is afford people to take more cases because we're only paying them $750 for a case. And this asks to raise it to $1,200. I've submitted a budget amendment, spoke with the team about that last week. And so if you approve of the idea, of course, I'd have to go to finance to see it through.
Okay, is there any question of the patron?
Mr. Chairman,
Yeah, Senator McDougal.
I'm not opposed to this, but what about the attorneys that are employing these or hiring these experts? Oftentimes, their compensation is not much more than what you're seeing here, and doesn't that create an inequity if we're increasing one but not the other?
Mr. Chairman, Counselor McDougall, I'm certain that is a challenge for the people defending them as well, but I did not address that in my bill. Legal fees should probably go up as well.
That's a different bill, right?
So that's not my.
Okay, any other questions of the patron?
I would move to report.
First of all, anybody here would like to speak in favor of the bill or against the bill? Okay, Senator Norman's been moved and seconded that the bill be reported. All in favor of the motion? And referred to finance, got to go to finance. All in favor of the motion to the bill be reported and referred to finance, vote aye. All opposed, vote no. Clerk will close the roll.
15-0.
Okay, the bill is reported and re-referred by a vote of 15-0.
Thank you, Mr.
Thank
Chairman,
you,
members.
Senator Mason. Okay, who's next? Senator Stewart, we ready for that? Senator Stewart's bill 154. Allowable purposes for restricted license.
Good morning, Mr. Chairman, members of the committee. Senate Bill 154 very simply allows you to go to the VEC to try to get a job on a restricted license. We've created a whole lot of loopholes on this, but, you know, sometimes folks see a hardship as a result of it, so it just allows them to try to get a job after they lose their license for a DUI.
Okay, is there any question of the patron? Senator Stanley.
Thank you, Mr. Chairman. Senator Stewart, you deal with these kind of cases as I do, people that get convicted of a DUI. We put the breathalyzer right there in the car, and we still restrict them in this way. But would you agree with me that, even though I think this is a very good idea, that under the rules, a person who's convicted of a DUI and has a restricted license cannot go to the gas station nor to a grocery store?
Not legally. They can stop by if they're in their lane of travel, but you know, you still wonder about that because technically I don't even think they're supposed to stop.
They're not.
Quite frankly.
Mr. Chairman?
Yeah, Senator Stanley.
They're absolutely not. Would you take an amendment that would include grocery store and gas station?
You amend it however you like, Senator Stanley.
Mr. Chairman.
Perfectly amenable to it.
Mr. Chairman.
Senator Norman.
Senator Stewart, following up on the direction that Senator Stanley was going, would you be receptive to a substitute that basically abolished the restricted driving permit if you had the ignition interlock in your car for the entire one-year period?
Senator Norman, I would be amenable to that. I'm carrying, you can get a DUI in your own yard. I might as well carry this one, carry that one too. Insurance companies and MAD will love me.
Senator Serval, yeah.
Mr. Chairman, I'm not being facetious about this. We have addressed this before, but we've got about 13 exceptions right now under the restricted driving permit, and the court right now must order the ignition interlock for at least 6 months. It just seems commonsensical if we would require it for the entire period of the suspended license and get rid of these ever-evolving exceptions. It just makes a lot more sense to me.
Mr. Chairman.
Is that a motion?
Mr. Chairman.
Yeah, Senator Serval.
Thank you. I know Senator Norman has carried that legislation in the past. At least when I was in the other body, I carried it last year, and it was killed in the Finance Committee because I believe the senator to his left had a scram bill that he was interested in pushing. I've introduced Senate Bill 439 this session, which does exactly what Senator Norman is asking about, and so I was trying to make that point. Okay.
Mr. Chairman?
Senator Senator
Make
McDougall.
And the bill that Senator Serval referenced, I've introduced again. I do think that this is a real problem because the only way people are found to be in violation is if something else happens. Their license plate light is out, somebody hits them in an accident, any of those things, that's how they're discovered. We need to have a better system to make sure that I think the reason we have these provisions in is to protect the community. A better way to do that would be you can drive wherever you want as long as we're insured that you're not using alcohol. And there are, because technology has changed, there are multiple opportunities for us to do that. Scram bracelets or scram technology, which is secure alcohol transdermal monitoring. Yeah, I probably have that not exactly right, but close. Is a way to do that to ensure that people, in addition to ignition interlock, are not driving when they should not be and putting themselves and others in danger. So, Mr. Chairman, I hope as we look at this, we take up all of those things with the driving, because it is a real problem that you prohibit people from getting to the gas station and make life extremely difficult, which is not the goal, but we want to make sure the community is safe.
Mr. Chair.
Senator Searle.
Peterson.
Oh, I'm sorry, Peterson.
So let me make sure I understand, and maybe I'm directing this question to Senator Stewart, but maybe I'm talking to the people that made or are proposing the substitute. We would still keep restricted license as a term in the code, but it would refer to ignition interlock only and would not have restrictions on where you could drive. It would just be that you would use the ignition interlocks. Is that what we're talking about?
Mr. Chairman.
I think the amendment that Senator Norman was talking about was having an either or. If you want to maintain ignition interlock, then you don't have to have a restricted license. If you can only do ignition interlock for 6 months. So if you wanted to have ignition interlock, perhaps you could not have to have a restricted license, or you just do away with restricted license entirely and you just go to ignition interlock to make sure that the community is safe. So
how many bills are there, do we know, in this category? You got two? You got two?
One, I got one.
He has one.
Mr. Chairman.
Would you like to put these in subcommittee? Go ahead, Charles.
There are essentially 3 bills. There's Senator Stewart's bill, Senator McDougal's bill, and Senator Serval's bill. The Scram bill and the first-time non-restricted license.
Why don't we put them all in Senator Deed's subcommittee? How's that? And work out the differences. All right, without objection, all these bills will go to the subcommittee that Senator Deeds is having starting next, when? We'll figure it out.
Okay.
Okay, criminal law subcommittee, all these 3 bills and work it out, okay? Without objection. Thank you. All right. Next bill is, let's see, Senator Serval, 642.
Mr. Chairman, there's another one of our Christmas trees. All this bill does is it adds wage theft to the multi-jurisdictional grand jury's jurisdiction. Several of our Commonwealth attorneys in Northern Virginia have asked to have this authority so that they can prosecute non-payment of wages through the multi-district grand juries. We know that a lot of these employers cross county lines, and the purpose of the multi-district grand jury is to be able to conduct investigations and prosecutions for offenses that might occur outside or might occur across counties. And so that's basically all the bill does. It's supported by, the Carpenters asked me to put the bill in, and I believe the AFL-CIO supports it, but they're not here. Many people aren't here today.
Mr. Chair.
Yeah, Senator Peterson.
Now, I'm very confident we had a discussion at least a session or 2 ago about just doing away with all these categories. And
we did.
Just having a general rule on multi-jurisdiction grand juries. Can someone refresh my recollection why we didn't do that?
We did, and I argued against it on the floor, and we killed it on the floor. And at least what I argued on the floor was that granting the Attorney General plenary authority to prosecute any crime anywhere in the state would be usurpation of our local Commonwealth attorney's discretion to prosecute cases the way they felt the case ought to be prosecuted in their locality. And so personally, I didn't like opening everything up to the Attorney General to prosecute anywhere in the state. I thought there's reasons we have Commonwealth attorneys because they're there to exercise local discretion, decide what and who to prosecute in their counties. And so the purpose of the multi-district grand jury was to go after crimes that specifically cross county lines. And I think this particular offense sort of meets that criteria. That's at least that's how I remember the discussion.
Mr. Chairman.
Yeah, Senator, Senator Stewart.
And let me piggyback to that, because I think Senator Serval argued almost as vociferously against expanding multi-jurisdictional grand juries as I did. And I've had experience with this as both a prosecutor and a defense attorney. They have become a rubber stamp. What was originally supposed to be a check and balance, they merely are nothing but a rubber stamp from what I have seen and I have a great deal of concern about expanding them any way, shape, or form, because when you do that, you tend to more legitimize them, and you perpetuate this thing. And much as I like Senator Serval and understand what he's trying to do, I don't think we should expand multi-jurisdictional grand juries at all. I think we should actually limit them to what their original purpose was, and even do more with, even restrict them more than that.
Any other questions?
Mr. Chairman?
Yeah, Senator McDougal.
Not a question, but a statement. I just want to echo what Senator Stewart is saying. When you start expanding this or opening it wide open to do anything, then it's not just limited to what could potentially be a good purpose. It means a Commonwealth's attorney in any jurisdiction in the Commonwealth can invoke a grand jury to investigate anywhere else in the Commonwealth. And, Mr. Chairman, I just think that it's a bad precedent for us to set.
Any further questions or comments? Let me ask you, Senator Serval, is wage theft a felony or a misdemeanor, or it depends on how much is involved?
Exactly, it's both. Depends on the amount of wages that are stolen. If it's over $10,000, it's a felony. If it's $10,000 or less, it's a Class 1 misdemeanor.
Okay. All right. Any other questions? Yeah, Senator Morrissey.
So Senator Serval, which argument of yours do you want me to focus in on? The argument where you argued so strenuously against expanding the scope of multi-jurisdictional grand juries, or this one where you're adding another ornament?
Well, Mr. Chairman, what I would say to the senator who wasn't here for our debate, I think it might have been last year, in fact, was the proposal last year was by Delegate Gilbert, and he wanted to give a multi-district grand jury the authority to prosecute anything, anywhere. And that was what I opposed. This bill that's in front of you has the Christmas tree on it, and the Christmas tree, I think, is mostly focused on drug offenses because, you know, drugs tend to cross county lines, and gang stuff. You know, these wage offenses tend to involve employers who operate across county lines, and they don't necessarily only operate in one county. Some of these contractors that don't pay people or classify right or whatever. And at least I can tell you that with some of the changes we've had in Northern Virginia with our new Commonwealth attorneys, they have a specific interest in prosecuting wage theft criminally, and they feel like in order to be able to do that effectively, they need to be able to look at more than just prosecuting or going after a defendant that's located in the county they're in, because it happens at multiple job sites.
Mr. Chairman?
Yeah, Senator Morrissey.
Speaking to the measure.
Yes. Go ahead.
It was about 30 years ago when I became really vested in the multi-jurisdictional grand jury when I was Commonwealth attorney, and we were focusing on homicides that were committed across jurisdictional lines, drug trafficking, and it was mostly limited to that. And if we go down this route, and I'm not saying that we should or should not right now, but if we go down this route, we're giving more and more authority to a body, i.e. a multi-jurisdictional grand jury, to investigate matters that perhaps should be the bailiwick of the individual jurisdiction. There's no doubt in my mind that Senator Serval is correct that there is wage theft going on that crosses jurisdictional lines, just as there are bad check thefts and credit card theft checks that cross jurisdictional lines, but we leave that to the auspices and the bailiwick of that local jurisdiction. Sometimes you have two jurisdictions that are investigating and the person is charged in two separate jurisdictions. We just got to be careful if we want that special entity, a multi-jurisdictional grand jury, now to be able to investigate a rather pedestrian charge, and I say that respectively, and that is wage theft.
Senator Serval, I have a question. Is this happening with, like, one company has different locations? And if that's the case, couldn't the main charge be wherever the headquarters is, the decision-making headquarters? That would be one place.
I think it would depend on the crime and where the thinking occurred. I mean, I don't know whether it could be a job manager on site making the decision, or whether it's made back at the mothership. But all I can tell you is that what I've already said in terms of the local Commonwealth attorneys would like to have this additional authority. And at least I can tell you, at least in North, I never was a prosecutor, but it's my understanding, at least with regard to the multi-district grand jury in Northern Virginia, that it's run by the Attorney General's office in cooperation with the Commonwealth attorneys, and it doesn't get involved in anything unless a local Commonwealth attorney asks it to. And so I think there's an additional check in there with the Attorney General's office.
Senator Boysko.
Thank you, Mr. Chairman. Senator Serval, could you give us some examples of what's going on now? I know in Northern Virginia specifically, which you discussed, there's so much building going on, and the labor market is very tight. I'm interested to hear from you what kind of stories you've heard from the people who have been experiencing wage theft and the problems that they're having getting their cases heard and treated fairly.
Yeah, so I think what it mainly relates to is misclassification of workers and failure to pay overtime to people that are working more than 8 hours a day on job sites. There's a lot of folks who just don't get involved in the legal system for obvious reasons, and also these cases are often, an individual case is often so small that it's not worth it for a lawyer to get involved, and people don't even think to call a lawyer. But when it happens on a mass scale and you're talking about dozens and dozens of employees who are in group getting having money stolen from them effectively, it can run into the tens of thousands of dollars. And right now, or at least our civil remedies under today's law are not very effective. There's a couple bills pending to enhance the civil remedies to make it easier for people to sue over these things. But I think also many of the Commonwealth attorneys in Northern Virginia that just ran on a platform of being more aggressive about these wage theft cases, and they think that they can use these criminal remedies to gain better compliance.
Mr. Chairman.
Yeah, Senator Obenchain.
Let me give you an example of how this respectfully can be misused. We had a large Virginia-owned transportation company in Western Virginia, my region. There were some complaints made about overtime pay, about things that typically would fall within the ambit of Department of Labor and other regulatory entities. The federal government, not state government, but the federal government, the Department of Transportation, got involved and conducted an investigation, largely talking to disgruntled truck drivers, and they indicted the company and its owners on 140 counts, felony counts, 140 felony counts for what was essentially regulatory violations. The company vigorously denied that it had done anything wrong, and I believe that it did not do anything wrong, and certainly did not do anything with the intention of doing anything wrong. Ultimately, on the eve of what was going to be a 12-week trial, the government yanked the chain and invoked their forfeiture. Bank pulled their credit line. The company closed down. 700 drivers were thrown out of work, and the company conducted a fire sale, only to have the government accept one misdemeanor, federal misdemeanor, the federal equivalent of a reckless driving charge, as the disposition in that case that started out with 140 felony counts over a wage dispute. And, I'm very concerned about criminalizing what is a fundamentally regulatory and civil scheme. I think that there are clearly some cases in which it is criminal conduct, but to open up the special grand jury process to give them the power of investigation and indictment in this way, I think is just fraught with hazard and is going to kill Virginia businesses unnecessarily.
Okay, Senator Norman.
Thank you, Mr. Chairman. I would respectfully move that we gently pass this bill by indefinitely.
It's been moved and
Mr. Chairman.
seconded that the bill be PBI. Senator.
Yeah, could I just say with
Sherwood?
regard to what Senator Obenshain said, his concern is that this behavior shouldn't be criminal. That, we already crossed that Rubicon a long time ago. This bill's been on the books for a long time. I don't think that's really the issue. The issue is whether or not we want to enhance our Commonwealth attorney's ability to be able to prosecute these offenses. And they are endemic. They're a huge problem. They're a huge problem in areas where we have lots of construction, like Northern Virginia. We have multiple bills pending this session to enhance our remedies on that, and that's why we need to have this authority coupled with the additional civil remedy that we have coming.
Senator Stewart.
Thank you, Mr. Chairman. Speaking to that motion, Mr. Chairman, what concerns me more about this, and perhaps I didn't express myself earlier, when these folks who may be seeking redress for not being paid their wages come into a grand jury, they can be quizzed for hours about anything. And most often you're not talking about people who are suspecting that they've done something illegal, but you're putting them before a multi-jurisdictional grand jury, and they will be questioned and questioned and questioned, not just about the wage issue, but about all of their activities, and anything they did could result in a criminal charge. That scares me. And that's why I think this is such a bad idea, and that's why I don't like multi-jurisdictional grand juries in general, quite frankly. It's very, very concerning, and these folks you're going to see a lot of mistreatment to the folks who are coming to try to get help.
Senator Morrissey.
Speaking to the motion, I echo some of my colleagues' comments about government overreach, but I wanted to share this with you, Senator Servell. You had indicated that in Northern Virginia, the multi-jurisdictional grand juries are under the auspices of the Attorney General's office. At least here in Central Virginia, I don't know what it's like up there, but you may have a multi-jurisdictional grand jury involving Henrico, Hanover, Richmond, and Chesterfield. There is, and Mr. Benjamin will correct me if I'm wrong, but there's no Attorney General oversight. It's conducted by the 4 Commonwealth's attorneys in those respective jurisdictions. And I would say to my colleagues on this committee, if there is one Commonwealth's attorney who still believes that, for example, wage theft is rampant, there's nothing prohibiting that Commonwealth attorney from seeking an indictment in his or her respective jurisdiction. So for those reasons, particularly overreach of what was originally supposed to be a limited wheelhouse of a grand jury, I'm going to support the motion to gently pass it by.
Senator Sherwood.
I'll just note that under 19.2215.2, a multi-district grand jury cannot proceed until the Attorney General's made an application for it. So I think the Attorney General's consent is required for it to look at anything. So, right, to set it up.
Mr. Chairman, only to establish it.
Yeah. Okay.
And then there's no guidance or governance whatsoever after that. Just the local prosecutors run it after it's already been established.
Senator Norman.
I move the pending question.
Before that, Senator Sherwood. Yeah. Are there anybody like to speak for it? Any Commonwealth attorneys down here to support the bill?
No, I received a text from one person that said that he was run into a gun protester and he's not in the building yet.
Oh.
And I believe the Attorney General's office probably didn't send their staff over here today for obvious reasons, and I suspect they probably support it, but I have not heard that specifically.
You want to wait till this person gets here?
Mr. Chairman.
Shall we move ahead with the?
Scotty, how many bills do
Mr.
you
Chairman, I missed the obvious reason since we're all
have?
sitting
Like
here.
50, you can lose one.
Why they're not.
60?
I think the governor has directed his staff not to appear at any committee meetings today because of what's going on. I suspect the AG's office is probably the same. And I'm fine just proceeding with the
It's
vote.
been moved and seconded that the bill be gently passed by indefinitely. All in favor of the motion, say aye. Vote aye. All opposed, vote no. The clerk will close the roll.
Ayes 10, noes 5.
Yeah, thank you, Senator Sherwood. Ayes 10, noes 5. The bill is gently passed by indefinitely.
You got 59 left, brother.
Okay, Senator Deeds, Senate Bill 415, which is compensation for wrongfully incarcerated annuity term.
Mr. Chair, this bill's perspective only. That's why it doesn't have an instruction to go to the Finance Committee. What it says is that if a person has a claims bill who's been wrongfully convicted and their life expectancy is less than 25 years, you will use the life expectancy rather than 25 years for the annuity. Last year, I sponsored a bill for a guy named Gary Bush, who was convicted of 2 offenses, one in Prince George County, one in Petersburg. He was incarcerated for about 11 years. He turned 70 years old this year. He's not in good health. However, the law says that his annuity, the claims bill was successful. The annuity has to be paid out over 25 years. Even if he lives his life expectancy under 8.01-419, that's 14.1 years. That's why this bill's in. He's got this 25-year annuity. He's highly unlikely to live that long. This bill won't affect him, but it will affect those people that have claims bills in the future.
Senator Dees, if he's going to die before doesn't the 25 years still pay out to his family?
It does, but he was incarcerated. This man was incarcerated for 11 years.
So you want to?
I would suggest that the payment should be to the person rather than the family.
So the bill would do what again?
The bill would say the annuity has to be paid out over the life expectancy if that's less than 25 years.
Okay. Is there anybody speaking in favor of the bill? Any questions of this patron?
Just a question, Senator Deeds, right now, is there also the alternative that the payment can be a lump sum payment?
Under the bill, I don't know.
Not necessarily under this bill, but right now, if an individual is wrongfully incarcerated, can there be under other legislation or other existing law, a lump sum payment?
I don't know if that's possible. When Mr. Bush brought this problem to me back in this year, later in the year, we contacted the treasurer to see if we could come up with a lump sum, if he could even sell the annuity, and there wasn't an option available.
Thank you.
Okay, Senator Stewart.
Senator Dees, I like and support your bill. I'm just wondering, do you want to give them a choice and say they could elect to have it at their life? Some people may want it to remain at the 25-year period for their families. Some people may want it to do.
Sure.
I don't know.
If you want to say they can use it, they don't have to, that's fine.
So just the person can elect. The person can elect to have the annuity period equal to his life expectancy.
May upon his election.
Or something like that.
Something like that.
I would move that amendment.
In concept.
Once Charles or Steve
You
comes
got
up.
an amendment here?
Okay, upon his election. Move that amendment.
So where would you put his election? Line 27 after that. All right, line 27 after expectancy?
After then. After then.
Line 27.
After then.
After then, okay.
Then upon his election, the annuity period shall be equal to his life
Yeah.
expectancy.
Then, in the new language, upon his election, end quote, before the annuity period shall be equal to the life expectancy. Is that right? Everybody understand that? Is the move been moved and seconded? Senator Dees moves, Senator Short seconds that amendment. All in favor of the motion say aye. Aye. All opposed, no. Motion carries. Any further discussion? Yeah, Senator Norman.
Just clarifying a question that Senator Morrissey asked. Under the provisions of the existing code section, there's you can have a 20% upfront lump sum payment, but 80% is amortized over that period of time. So there is a partial upfront lump sum payment.
Okay. All right. Any further questions of the patron? Anybody here would like to speak in favor of the bill? Anybody would like to speak against the bill? Is there a motion?
I move to report.
It's been moved and seconded to report the bill with the line amendment. All in favor of the motion, say aye. Vote aye. All opposed, vote no.
Thank you very much.
The motion, yes, the clerk?
Ayes 15, no zero.
Ayes 15, no zero. The bill is reported with the line amendment. Thank you, Senator Dees. Okay. Senator Obenshain, Senate Bill 699, fine for failure to respond to questionnaire.
Mr. Chairman, this comes to me from one of our circuit court clerks. It seems that every year they have increasing difficulty getting jurors to serve. And one symptom of this is they send out questionnaires at the beginning of the process to prospective jurors. And if they don't get a response from the questionnaire, it shrinks the pool of prospective jurors. Those people who don't respond don't even go into the pool of people who are called. In my county, Rockingham County, for example, there were 2,200 questionnaires that were mailed out. In Fairfax, it would probably be 22,000 that were mailed out. A full, I guess, 25% of those questionnaires were not returned. 575 in Rockingham were not responded. Clerk followed up with postcard, and still there were more than 400 who still did not respond, even after taking out the bad addresses and undeliverable questionnaires. The judge was ready to issue a show cause to those individuals who failed to respond, but looked at the code and thought he did not have authority to issue a show cause. So we've got a requirement that the clerks issue these questionnaires in order to qualify members of juries or jury panels, but there is, my understanding, no way that the court can effectively enforce that. And what the clerk wants is just to make clear that the court has the authority to issue a show cause and can issue a fine for people who don't respond to these questionnaires. And I was going to suggest a couple of changes to this draft in order to maybe give a little bit more discretion. First of all, I would suggest maybe reducing the $200 to $100, see how that works in line 16, and also after the word court in line 16, the word may, I would suggest probably needs to be changed to shall. Looks like great minds are thinking alike. So I think that the court should be required to issue a show cause before issuing a fine. I don't think that the court should impose fines without hearing or giving people an opportunity to be heard as to why they didn't respond. So I would first move those two amendments.
I'll second those amendments.
Any discussion? All in favor of the amendments to change?
Mr. Chairman?
Yeah, Senator Stewart, yeah.
Senator Obenshain, under the show cause provision of the court, doesn't the court already have the ability to hold them in contempt or do they not have any authorization other than the fine you would be placing in here? I mean, why do we need a fine? Why can't we just let them issue a show cause and bring the people in, let them answer the judge?
My understanding is that the court did not think that it had the authority to issue a show cause for failing to respond to a clerk's letter. I mean, this isn't a court order, this is a clerk's letter.
I'm sorry, no. Wouldn't they have enough authority if we gave them the ability to issue a show cause under this bill? Then wouldn't the court have other
Sure, they could.
parameters they could use without putting a fine in this bill?
This simply, and yes, I mean, if you want to give the court that broad discretion, my thought and my clerk's thought was, let's make sure that we put some brackets on the response, permissible responses to failure to respond to a questionnaire.
Mr. Chairman?
So,
Yeah, Senator Boysko.
Mr. Chairman, thank you. So if a quarter of the people who are receiving these are not responding, in my mind, that means there's something wrong with the method of communicating. Would you not agree that maybe we need to look at the broader reason? Maybe people are not checking their mail anymore. I know that I throw out almost.
and that may be.
Yeah.
But what the clerk's offices do across the state is, you know, they send the mail and then they follow up with another piece of mail. And if somebody gets a rule to show cause and appears and says, I didn't check the mail, or I moved, or my kids get the mail and throw it away every day, you know, that's an excuse. And my guess is by the time they get the show cause notice and realize what it's about, they're going to fill out the questionnaire. And they're going to go, and just like every judge in the Commonwealth, it's like not having a valid inspection. When you show up and show them that you've now got a valid inspection, they say, okay, go about your business. If you filled out the questionnaire, I cannot imagine that a court would impose a fine. They may give them a little bit of a lecture, but otherwise send them on their way.
Senator Peterson.
I have some of the same concerns Senator Boysko does, that people don't open mail, people are gone for months. I guess one of my initial questions is, why are we sending people a questionnaire? I mean, to my mind, if you're on the voting rolls, you're a potential juror, and once you're brought into the jury box, I mean, you can be asked questions in voir dire. What are we asking them questions about in a questionnaire?
The basic qualification questions. It is the initial screening to determine whether a person is qualified to serve on a jury. They have already popped up for having registered or having a driver's license and otherwise being qualified, but it asks questions like, are you a citizen? Or whatever. Are you a convicted felon without having your rights restored? It is an efficiency issue. If you're not qualified to serve on a jury, they don't pull you in.
I've never, and I've done more than I'm sure you have, I've done over 50 jury trials.
200.
I've never had that where it's not been a question in voir dire. Are you a convicted felon? Are you a citizen? Do you speak English? I mean, these are the types of questions that judges ask once. So I don't quite understand why we need to have this sort of pre-screening process, but maybe I'm missing something.
Well, what I would tell you is that's a different issue. We do have a pre-screening process, and if you want to get rid of that, go ahead. But it is an essential part of our current system of impaneling juries.
Senator McClellan.
Thank you, Mr. Chair. In answer to Senator Peterson's question, they also asked questions about if there are any dates that you know you would be unavailable to serve as a juror. And if I'm remembering correctly, they ask if you have any health issues that would make it difficult for you to serve as a juror, which if you have that information before you even begin voir dire, it's just an efficiency mechanism.
And as I recall, maybe somebody on this committee had a bill last year that said if you are a mom responsible for caring for children at home, you can say, I'm not available right now, but I want to serve next year.
Senator Morrissey.
Bill?
Senator, isn't there three aspects of this? Number one, a questionnaire is sent out. Number two, there's a screening process that goes on afterwards. And the final process is actually summoning a person for jury duty. Do I have that correct?
My understanding is that is correct.
Further question?
Yes, Senator Morrissey.
You're not questioning, this bill doesn't question what somebody's failure to show up who has been summoned to a jury, correct?
That is correct.
Final question.
Yes, Senator Morrissey.
It's just getting them to respond to the questionnaire.
Yeah, if they don't respond to the questionnaire, they don't even go into the panel of prospective jurors. It puts more of a burden on the other folks who are picked. It dilutes the representative nature of our jury panels. We want to make sure that people are tried in our courts by juries of their peers. And we count on people fulfilling that civic duty and responsibility, and this is just trying to be a gentle way to encourage people to perform that civic duty and responsibility.
Thank you, Senator.
Yes, Counsel.
Mr.
Steve,
Chairman,
Steve.
Senator Obenshain, when staff looked at this, we were concerned about just using regular mail and thought that it may be appropriate on line 14 to add the word certified and upon return receipt requested, which would accomplish several things. Number one, it would better ensure receipt. It would also give a way to determine when the 10-day period would begin, and may also have the collateral benefit of focusing people's attention on the seriousness of this questionnaire.
Well, I would say that that would fundamentally change the way that clerks' offices do this across the Commonwealth. It would result in a pretty big fiscal impact. I think that the questions about how we are communicating are fair questions. I think that that's something we probably should look at going forward. We are collecting a vast array of email addresses with DMV and otherwise, and I think it's worth doing that prospectively, but that's not what this bill really addresses. This bill addresses the current system, and I don't think that requiring every clerk, I mean, just think what the Fairfax County clerk would have to expend in terms of additional personnel and mailing costs if they have to send out every jury questionnaire by certified mail.
Senator, the practice of not summoning jurors who do not answer the question, is that just a practical practice, or why is that?
Well, they don't even go into the pool.
Why is that?
Because they have no idea whether they're going to appear. They have no information about their qualification, and it's just practice.
Okay. Mr. Chairman.
It's just the way it's done.
Yeah, Senator McDougal.
Mr. Chairman, having had some experience with the mail that's not always positive, I just have real concerns. Sent something the other day that should have been plenty of time to arrive, and about 10 days later got there. I got something in the mail last election cycle, literally 10 months after the person had sent it. Might have been closer to 11. So I would hate to have somebody show caused on that. I would maybe prefer they look at their practice of saying they summons the normal complement, or maybe a few or less of the people that respond, and then summons a lot larger of the people that don't respond. That would increase their pool and make sure they have enough there. But I do have a little concern about the reliance on the Postal Service for somebody receiving a fine or penalty from the government.
Anybody else have any questions? I have a question. What bothers me about this, we are continuing to put burdens on our citizens who've done nothing, just to do something. They got to do something, and sometimes they just want to be left alone. I mean, when people call for surveys, do you really have to answer the survey? Sometimes people just hang up.
Well, you know what? We have a constitutional right to trial by jury, which is, we're talking about fundamental rights. I don't think that there's anything more fundamental than the right to trial by jury in the criminal or civil context. And if you think that people shouldn't be bothered to do that, then we got big problems.
And I would agree that with the idea of, teaching citizenship. I agree with that.
I don't. This isn't a brochure bill. If you don't like this bill, you do what you want. But I think we've got a serious problem, and those of us who who have a trial practice, who try cases before juries. I mean, we know that it is important to have a representative jury, and in a lot of areas, it's getting pretty difficult to do that.
Senator
Mr. Chair.
Peterson. Yeah. Senator Peterson.
First of all, I have great respect for my friend from Harrisonburg. He's an excellent trial attorney. We've done cases together. I try cases for a living just like he does. I believe in the jury system. But I also think that you really need, I don't know what the sort of the phrase I'm looking for is, but I think we're introducing sort of an extra step here when we say, well, you got to fill out this questionnaire to get into the jury pool. To my way of thinking is, if you want a representative sampling of the community, you look at the registered voter list, you bring those people in. We have a process called voir dire where we can go through and ask people questions and weed out the people that are ineligible. But to have this extra step, to me, people don't voluntarily fill out forms from the government. I mean, they do if they're income taxes. I mean, in some cases they have to, but by and large, people don't want to voluntarily fill out forms from the government. So I think this is introducing an extra step. I've asked my colleague here, I'm not aware in Fairfax County we do this, maybe we do.
They do.
Well, I've never seen it. But the bottom line is, I just think we're adding in what, in my opinion, is an extra step that's just going to cause more distrust, and Lord knows we got enough of it, so.
We do have a motion.
I have a move to PBI.
Well, first of all, there's a line amendment, change may to shall on line 16 and change $200 to $100 on the same line.
If you're just going to PBI it, just go ahead.
You want to withdraw the motion?
Substitute
The substitute motion.
Mr. Chairman.
Yeah, Senator McDougal.
I do, since I think that first motion was withdrawn, I do have a substitute motion on the motion to PBI, and that's to carry over for the year. I do think I think Senator Openshane's focus on this is really important. I think maybe there's some other things that we could look at in the interim to come up with solutions that might not include the U.S. Postal Service, for which my confidence level is not as strong as for some other ways.
Perhaps we can enlist Mr. Dix and the Clerks Association and get them to maybe take a deep dive on this issue.
All right, it's been moved, and is it seconded?
Supreme
To
Court.
carry over the bill for the year and have somebody undefined to look at it. All in favor of the motion to carry it over for the year, vote aye. All opposed, vote no. Clerk will close the roll.
15-0.
15 to no, it is carried over gently for the year.
Thank you.
Okay, thank you, Senator Obenshane. Senator Saslaw.
All right, I have 947. There's an amendment in nature of substitute. I'll give you just a brief thing. Ultimately, I'm going to ask the bill to go by for the week because there are other problems that pointed out to me. Lines in the original bill 77 to 79 concern the executive secretary office. And they said that if there's an automatic order for expungement after the acquittal and the individual charged and acquitted may not file a petition to accompany the expungement order, and there may be situations in which they weren't fingerprinted, and as such, there would be no fingerprints to accompany the order. Well, our counsel, they have a substitute which corrects that. That may be on your desk, but Senator Servell said that he thinks that still it's overly broad and takes a lot of discretion away from judges. Mr. Quagliato thinks they can narrow that down, so I would move that we adopt the substitute, and then I'm going to make a motion that that it go by for the day.
Second the motion to adopt the substitute.
It's been moved and seconded to adopt the substitute.
Mr. Chairman.
Senator Servell.
Maybe council could enlighten us as to how many expungement bills we have before us this session.
Mr. Chairman, we have quite a few expungement bills, but I'd say less than 5. But most of the expungement bills deal with expanding who is eligible for expungement, where this is, I'll say, limited to those people who are already eligible under the existing expungement statute. So that's why this might be in a different posture than the other expungement bills.
Is there,
Mr. Chairman?
Yeah, Senator Servell.
I'd just like to point out, I know that in addition to those separate expungement bills, there's also the marijuana decriminalization statute, which had the whole expungement issue in it. And just, it seems to me that if there's going to be a significant redo of expungements, that maybe they ought to be looked at collectively instead of individually, and perhaps it might be something that the CRIM subcommittee ought to look at all in one docket instead of trying to deal with it piecemeal, but that's just...
Let's go ahead and adopt the substitute and then send it to subcommittee. All right, all in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. There's a motion, we send this to, I'm going to send it to the subcommittee. Okay. Senator Deeds is Criminal Law Subcommittee, and you're going to meet whenever he's going to meet. Okay, got to figure it out. If all the bills dealing with expungements will go to the subcommittee, and we'll try to figure it out, okay? All right, now, Senator Obenshain, you have a Senate Bill 693 that you would want to go by for the day, or what?
Mr. Chairman, I think we had communicated with your office, and you had agreed to allow that to go by for the day. The Virginia Trial Lawyers Association, and maybe, I can't remember, Chris, is that Boyd Graves' bill, that immunity? No? Oh, y'all don't like it. Are you here for that? You are? Oh. Well, we'd asked the chair to allow that to go by for the day because of the inability of the trial lawyers to get a witness here. As was evidenced by the last bill, I need help, so.
Okay.
Mr.
Yes,
Chair.
Senator Peterson.
We're going to have the Civil Laws Subcommittee probably next Monday at 4 p.m., and I don't know if that would be...
Would you like for that to go to subcommittee?
I think it would get a receptive audience, Senator Obenshain.
All right, we'll send that to subcommittee next Monday at 4 o'clock. The Common Law Defense of Intra-Family Immunity. Yeah, Senate Bill 693 will go to the Civil Law Subcommittee that Senator Peterson chairs, okay? The only other bill is my bill, which is the best bill, and no, it's, I just need to, I'm asking that go by for the day. Have the number of judges.
Second.
Senate Bill 973 go by for the day without objection. Okay, any other matters that come before the committee? Charles? Senator Norman? Yeah, you want to judge?
Yes, sir. I'd like to renew my motion to certify the judge that was previously removed from the certification list.
Well, Senator Morrissey and Senator
Morrissey,
Lucas.
Excuse me, Mr. Chairman. Senator Morrissey asked me about the process, and I explained to him that this certification just meant that the judge was eligible for reelection. It was not a reelection and did not preclude further discussions.
Okay. Is there been moved and seconded that we certify this judge?
I'll second it.
Any discussion? All in favor of the motion, say aye. Aye. Do we have to vote on this? I guess we did. All in favor, vote no, vote yes. All opposed, no, no. It's a voice vote, okay.
It's a voice.
All right, all in favor say aye. Aye. All opposed, no. Motion carries unanimously. All right, thank you.
Thank you.
Is there anything else to come before the committee? We shall meet on Wednesday afternoon after session. All right, thank you very much. Thanks for coming.